Hey guys, welcome to week 7. I'm Mr. Moore, and this is for the 12th grade Gov and Economics class. This week we're going to be focusing on the judicial branch, that is the Supreme Court, and really the entire federal court system. And we're looking at its role in interpreting the Constitution. Um, I always try to start off my notes with an essential question to get students to focus on, and for me as the teacher, to help focus on what really matters and where these notes are going, the direction that we're going in class here today. The essential question is, what is the judicial branch of government in the US? And that answer is the Supreme Court. What's it called? The Supreme Court. But really, it's not just the Supreme Court. That's the top court in the entire country. But there are lower federal courts. There's a whole system of courts. If you get denied in one court, like you're found guilty in one court, you can appeal an appellate court, right? So you can work your way up to the Supreme Court. If a court if you lose in one court and you appeal to a higher court, but the higher court refuses to hear your case, then the lower court's ruling stands. So the top court in the United States is the Supreme Court, kind of like a ladder, if you will, but that's the entire judicial system. What are its powers? It has the power to judge whether a law is constitutional. In other words, whether a law is a good law, whether it should be a law. And the court does have the power through the process of judicial review to strike down a law that it deems not constitutional. And that's really what we're going to get into this entire day. And hopefully by the time we're done with these notes, you're understanding some of those concepts. So if the power of the Supreme Court is really to interpret the Constitution, as you can clearly see, to interpret the Constitution, I think it's important for us to quickly review the Constitution. Remember, the Constitution is a document. Back in 1787, the Articles of Confederation were not working. That was a set of documents, articles, obviously Articles of Confederation, that were trying to tie the 13 colonies and then 13 states into a unified country. But it didn't give the central government or the federal government any real significant power. And so states sent delegates, and they met together and they tried to, at first, adjust and fix the Articles of Confederation. But in the end, they decided to scrap the Articles of Confederation and to write a new constitution. So the new constitution is being worked on in 1787 and 1788. But by 1789, it was in full effect, and we got our first president, okay? The Constitution starts off with the preamble, where it starts off with those famous words, "We, the people of the United States, in order to form a more perfect unity and establish domestic tranquility and provide for the common defense," right? And we've read that together in class. It's one of the most poetic and beautiful parts of the Constitution. It's very short. It's like a paragraph long, but it really lays out the basic ideas of government in our country. And then the longest article is the first one, Article 1, and it lays out the powers and the proper names of and the qualifications for serving in the United States legislative branch, which of course we call Congress in our country. And Congress is divided into two parts, the House of Representatives and the Senate, right? And so in Article 1, you'd find all the different pieces of the puzzle as to what Congress is legally allowed to do. Okay, Article 2 is all about the executive branch. And we've already lectured on these in class. The executive branch, of course, is the president and the vice president and their cabinet that helps run the different departments of the executive branch. The job of the executive branch is to enforce the laws or to execute the laws. As the legislative branch, the job is, of course, to make the laws, right? Now, we're going to be dealing today really with Article 3 of the Constitution. And Article 3 is all about the judicial branch. And the judicial branch of government, as we've been stating here, has the power of judicial review to interpret the Constitution and to see whether the laws that are made by the legislative branch and enforced by the executive branch are actually constitutional. Okay? And they're kind of the go-between. And of course, we're always talking about that idea of checks and balances, having those three separate branches. so that one branch doesn't overpower the other. And they go through different phases. Sometimes the Congress, the legislative branches, has the power that the founding fathers, kind of foresaw. The power of the president has been growing exponentially over time, especially after World War II, when Franklin D. Roosevelt broke tradition and ran for more than 2 terms in office. In fact, was starting his 4th term when he died in office right before the end of World War II. Okay, the judicial branch is what we're going to focus on today. But just to remind us of the other pieces of the Constitution, Article 4 is all about the states. What's required to become a state, how states should interact with each other, how the laws in one state still hold some effect in other states, but not really. I mean, like for instance, in Oregon, they don't have sales tax, but in California they do. So if you buy, say you were going to buy a PS4 or something like that in California, and the price said $299.99, right? Like just a cent less than 300. The fact is if you bought that, like at Target or Walmart or Costco or wherever you're going to buy it, you would have to slap on, depending on what county you're in, a certain amount of tax. It could be like $350. So you're like, wow, that's a lot of extra money that's going in tax when you buy stuff. In California, we don't charge sales tax on food. So when you buy an item of food, it's exactly what it says it's going to be. But if you buy anything else, then they're slapping on sales tax. But if you go up to like Oregon, they don't have sales tax. So if you sell a PS4 for $299.99, then it legitimately would be exactly what it says it was, just like food is in California. And of course, they have gambling in Nevada. So how states interact with their laws, that's all. Article 4 is kind of focused on that idea. And even though it's not specific on everything, it does kind of lay down the foundations of how that works. And also, if I get married in Utah, but then I move to California, I'm still legally married, even though I was married under Utah law. So there's that interconnectedness of states that's a really big deal. Article 5, of course, is one of the most ingenious parts of the Constitution because Article 5 allows people, the states and Congress, okay, but there's a lot of qualifications, and that's one of the things that we'll look at later on. But how do you change the Constitution? If you want the document to stay a living document, you need to be able to change it, but it can't be too easy to change, or else people would change it for whatever reason they wanted to. So that's Article 5, and that's what allows us to have amendments to the Constitution. Okay. Article 6 is national supremacy. If you have 13 states, you want a federal government that kind of oversees all 13 states. And of course, today we have 50 states. When we first started 13, but they wanted to make sure that if there was a law in a state and the federal government made a law and they were kind of in opposition to each other, the federal government's law would supersede the state law. National government is supreme, or the federal government is supreme. And number 7 is honestly, and I mislabeled that, so I have to go back and fix that. But Article 7 is all about ratification, right? Ratification means just signing it and all the states getting into it. So I'll go back and I'll fix that typo here in just a few minutes. In fact, I'll just do it right now so that we don't have that problem in the future right here. And of course, the amendments are added at the end. Those are addition or changes to the Constitution. And by the year 2020, there's only 27 total amendments. So that is, the Constitution has been changed only 27 times, but the first 10 were done right away. I mean, within the first year or so of building ourselves a new nation. And those 10, the first 10 amendments that are amendments to the Constitution, are sometimes referred to as the Bill of Rights. So are the Bill of Rights a part of the Constitution? Kind of. They are the first 10 amendments. That is, additions or changes that were added in there, okay? So I think that's really important to pay attention to. We always like to propose questions. If we're in class, this is the part where we might pause and have some discussion. But what makes a law or an action unconstitutional? And does that determination ever change? So when people make laws, and that is Congress, the legislative branch of our government, makes laws, sometimes people feel like those laws are not just, they're not fair. And so we bring into question, is it really helping us to have domestic tranquility, or to provide for the common defense, or to establish justice? And some people challenge that and they say that's not fair. And there's been all kinds of really significant Supreme Court cases that we'll talk about at the end of the notes today, where people challenged and said, I don't think this law is a good law. And sometimes those laws are, scratched off the books and become invalid laws. So there are laws that are made that end up swept away by the Supreme Court. And then those people who were found guilty of breaking a bad law, they could be released, or have a less sentence, or depending on the answer is always, it depends on what the crime was, what the law was, and how the courts interpret it. Okay, so let's go over some of the basic facts of the judicial branch, the Supreme Court, and the federal court system. The judicial branch is the entire court system, or judges in our country, right? There are, and here's a little tricky thing, there are state court systems and there are federal court systems. So it depends on what law you break and who arrests you. If you break a state law, then you would end up in a state court system. If you break a federal law, then you could end up in a federal court system. And it all depends on who does the arresting, and here's a fancy word, who has jurisdiction, right? Who has the ability to hold you accountable for the law that was broken. Okay, so the judicial branch is the court system, or judges in our country, and of course the top court is called the Supreme Court. The Supreme Court has the power to review or interpret a law to determine if the law is constitutional. People refer to this as judicial review. There are federal courts and state courts, as just mentioned, okay? Thus, there are federal prisons and state prisons, right? So again, it kind of depends. That's always the answer when it comes to breaking the law and what kind of trouble you're going to get into. It depends on what kind of evidence they have against you. And it depends on how the jury in the court system, and we'll talk about juries in just a few minutes. So there's so many different factors that it's impossible for me pre-recording these notes to answer all questions right here. But I think it's important to understand it. If you break a federal law, you could end up in the federal court system. If you break a state law, you can end up in the state prison system, the county, county jail, as opposed to, the state pen, right? State penitentiary. Where you serve the time depends on the crime, right? There's also different kinds of courts. There are trial courts. And if you lose in a trial court, you can always appeal that to a higher court, an appellate court. That's a court of appeals. And then there's also things you have to pay attention to, like who has original jurisdiction. Again, it depends on what kind of crime you commit. Now, if you're thinking, man, this sounds really complicated, it's true, it's complicated. That's why when people go to court, they hire themselves a lawyer. And that's why lawyers get paid big money, because they spend years and years going to law school, learning all of the different laws, and so that they understand how to navigate the court system. A regular person like you or me would not really be able to navigate the court system. I mean, we could take time and study up and learn it, but if you're arrested and in trouble, you need somebody who's already done the studying and learning. And that's why lawyers become so important, is you want to make sure that you have somebody who's representing you, right? Legal representation, who can understand the complexities of this court system. All right. There are also criminal courts and civil courts. So a criminal court is a citizen versus the government. In other words, a criminal court is where somebody broke a law, or at least they were accused of breaking a law. Remember that in our country, we believe in this concept of that we're innocent until proven guilty. So thus, if you go to court and you're arrested for robbing a bank, you're not guilty until the court, the prosecution, can pull enough evidence and convince the jury that you actually robbed the bank. Remember that the prosecution has the burden of proof. They're the ones who have to prove you're guilty. You're innocent unless they prove you guilty. But remember, in a criminal court, then, it's really the citizen versus the government. And so, depending, again, it always depends, but there's usually like a district attorney. That's like the person who's enforcing the local laws, and they would be the one who try to mount a case against you. And so there'd be a prosecution who's trying to prove you're guilty, prosecution, prove you're guilty. And then there would be the defense, right? Trying to defend yourself and say, no, I'm innocent. And then if you can convince the jury, remember that in most courts, now, again, it always depends on the crime or the situation, but usually it's a jury that decides if you're innocent or guilty, and the judge's job is just to make sure that the law is being followed in general. Now, sometimes there's no jury and the judge will just pass sentence. Again, it always depends on the crime, the level of the crime, if it's a small misdemeanor versus like a felony kind of a charge. So again, there's lots of the word "it depends" when we're talking about this. There's a different kind of court, though, where nobody broke the law. I know that might sound weird. How could you go to court if nobody broke the law? But there's what we call civil cases. And that is where a citizen versus a citizen. And nobody broke the law. Let's say my neighbor's dog gets out and comes over and chews up my porch furniture, ruining $1,000 worth of porch furniture. And I go over and I talk to my neighbor, and I have pictures of his dog doing it, right? And I had to shoot the dog off. And I say, hey, dude, you ruined $1,000 of my furniture. Now, if I have a good neighbor, that neighbor will step up and say, I'm totally sorry. Here's the money. And we could just fix it without a court, right? If you have good neighbors. But if you have a neighbor who's a jerk and who's like, well, prove it, then you could take that neighbor to court. Now, the neighbor's not in trouble with the law. They didn't break any law. But at the same time, I want to make sure I get my porch furniture fixed, right? And so I could sue them in court. And again, nobody's going to jail, but a judge kind of sits there and said, listens to the evidence. And you might have a jury if it's a big enough, if it's worth enough money. But again, nobody's going to jail. It's citizen versus citizen. So I think that's really important. And I really want you to highlight that in your notes. There's criminal courts versus civil courts. Okay. That's a huge deal. The Supreme Court is really judges, and the Supreme Court has 9 judges. Okay. Justices, as they're called. And of course, there's one Supreme Court Chief Justice. Okay. How do you get onto the Supreme Court? You're picked by the president. So the executive branch gets to pick who's going to be on the Supreme Court. But if you're on the Supreme Court, you get to serve for life. In other words, like the president only gets to serve 4 years, right? 1 term. And then they can run again. And if they're voted in again, they get another 4 years. But if you get picked to be on the Supreme Court, you can serve for life or until you retire. So the president might not get to pick any Supreme Court justices. If there's 9 on the bench, figuratively speaking, that's what they say, sitting on the bench. So if there's 9 Supreme Court justices and all of them are healthy and happy, and say I'm serving as president for 4 years and those 9 people are still on there, I might not get to pick any if I was president. Even the next president might not get to pick any. But say the president after that, 2 of these justices get really old and are ready to die or retire, then people who are voting for the next president might say, this president's going to probably get to pick a new Supreme Court justice. And that kind of determines how they might vote. Okay, because obviously if you had a liberal president, they would pick liberal Supreme Court justices. If you had a conservative president, they would most likely, of course, pick a conservative Supreme Court justice. So it's a big deal. If there's an opening coming up or an anticipated opening coming up, that can be a big deal. Okay, so what is judicial review and how does it work? Again, if we were in class, this is the part where we could pause and have a little discussion. Recording these, of course, so that people can get the basics of it down. That's kind of where you could pause and kind of think of it. We're reviewing the laws to see if they're actually good laws, if they're fair and just and equitable, and making sure that they're not there's not unintended consequences That's a fancy word, because sometimes we think we make a good law and it turns out that it wasn't good, right? And so, and how does that work? Well, if you keep appealing your case and courts keep taking them and you keep losing, and you can end up all the way in the Supreme Court. And the Supreme Court gets to choose which cases they're going to take. They might get thousands of cases that people appeal to the Supreme Court, and they go through and pick out a handful that they're going to cover each year. They try to pick the ones that are the most controversial and the most like going to have an impact on issues in the entire United States, because once they make a decision, then lower courts will follow their example, and the Supreme Court can set a precedence for lower courts. Okay? So who are the current Supreme Court justices as of 2020? We can see a list. Oftentimes they are very much older. And you can see right here a list. I actually put in a little link in my notes so that you could, if you click on that link, it will actually open up, and you could see the actual, Supreme Court, and you could see on like opinions that they're working on. Okay, you could look at things like about like the justices. If you clicked on this one, you could always find the list of the current justices. That's where I snagged the picture from. And then you could see the current members, right? And you could see little bios on each one of them. And these are people who served as judges before, probably, like there's no requirement, to be honest, in the Constitution, but they all go to law school, and you can see where they went to law school and where they worked as lower judges. So if you are a really good judge in a lower court and you built yourself up a good, reputation, then you might have a chance to be picked by the president to be on the Supreme Court. So again, this is where you can come and check out the Supreme Court and see, again, what they're working on, and who voted what direction, because there's 9 of them, and you can kind of see some of the different cases that they're working on and when they were working on those Supreme Court cases. So that's kind of a really important thing. And of course, the Chief Justice right now is John Roberts as of 2020, right there in the center. That way there's not just 8. If there was just 8, you could really end up with a tie all the time. But by having 9, you always get that, pushed over the edge one direction. That way you don't have a court that's like frozen, right? That's a really important thing. Now, here's a really important word called federalism. And what this important word means that there are 3 branches of government at the federal level, but there is also 3 branches of government at the state level. Wow. So if you go to Washington, D.C., okay, then you would find the U.S. House of Representatives and the U.S. Senate that makes the laws for the entire country. But in California, we also have a legislative branch up in Sacramento. And we're going to continually talk about this kind of concept. So there are 3 branches of government at the state level in California. In fact, every state has its own 3 branches. So the legislative branch in California is called the State Assembly. And the State Assembly is what makes the laws for California. Okay? And then, of course, we have an executive branch in the state of California, the governor, Gavin Newsom, in 2020. So that's really important to pay attention to. And, of course, we also have a judicial branch at the state system, where the judicial branch interprets the laws and disputes just in the state of California for California laws. And that it literally is called the California Supreme Court. So again, there's 3 branches both at the federal level, and there's also 3 branches at the state level. And that's why government can be very complex. And again, honestly, why lawyers get paid tons of money, because they spend years going to law school and learning all of the particulars. And there's different kinds of law, from environmental law to corporate law to marriage and family law, to educational law. I mean, you don't just study the whole law, you actually specialize. Just like a doctor might become a heart surgeon or a brain surgeon, those are 2 entirely different things. Both of them, would go to med school, but they would get a specialty. You know, I have some people in my family who have gotten doctoral degrees, and there's one of my brother's father-in-law. He specializes in foot and ankle. You know, so you really specialize in medicine, but you also specialize in the law because it can be so complicated. Okay. The Supreme Court, of course, is located in Washington, D.C. And that's why it says Fed, as in federal government. That's right in between Maryland and Virginia. But before you go to the Supreme Court, say you get arrested in California and you go to a local court, but you don't think it was fair because you really are innocent, even though they said you were guilty. If you can find the right lawyer to help you appeal, then you can move on to a court of appeal. And so there are district courts, courts of appeal, and of course the Supreme Court. And you can see that all of these states right here are in the ninth. Okay, there's 12 circuit courts. Okay, and they don't deal with original jurisdiction. Okay, they're strictly appellate. That means you're appealing. You only appeal if you lose. If you win the case, you're off, right? You don't go to jail. You're not in trouble. But if you lose your court case, you can appeal to a higher court. Imagine how important that would be to know, right? If you don't understand how that works. So if you get in trouble in California and you lose your court case, but you really feel like you're innocent, then you could appeal to a higher court, and you might end up, going up in these district courts, and then you might end up in a court of appeals in these 12 regional. And then if you still lose, then you could bring your case before the Supreme Court. But again, the Supreme Court can only handle so many cases, so they might throw yours out. It's kind of like the ultimate place to go because the Supreme Court trumps. I mean, not as in Donald Trump, the president. I mean, but like wins, right? And their ruling supersedes lower courts. Okay. Here's a little diagram and charts. If you know somebody who's gotten arrested, or you yourself have legal troubles, or you're just curious, you can kind of look at this and kind of see, if you got in trouble for something small in Apple Valley, you might end up at a county court. But again, if you win in county court, you're done, right? You're cleared. But if you lose in county court, you could maybe appeal to a circuit court. And if you still lost there, and it kind of gives you some of the, like what would be included, just some basics. Obviously, that word "it depends" is really significant. And then, of course, you could appeal to a higher court and eventually all the way to the Supreme Court. So these are just some little charts trying to show you how the U.S. federal court system works. And again, you only appeal if you lose. If you win, you're done. Okay? Here's some very important Supreme Court cases. There has been thousands of Supreme Court cases, but these are the most significant. Probably the earliest and most significant that really gives the Supreme Court the power it has today is something called Marbury versus Madison. It was in 1803, and I'm not going to go into all of the details here because this is just a basic gov class. But really, it established the Supreme Court's power of judicial review, the right to declare a law unconstitutional over Congress. Remember, Congress makes the laws, President enforces the laws. This case right here is really the one where the court said, you guys screwed up. Like, this law is not just and fair. And Congress and the president didn't step on the Supreme Court. They respected the Supreme Court and its decision, which kind of gave precedence for future court cases. So you can go Google this. I actually have some videos where you can watch and learn all about it if you're more interested. You want to make some good money in life, become a lawyer, then you're definitely going to want to get into some of these things. Probably one of the worst Supreme Court decisions ever was the Dred Scott decisions. It was right before, you can tell date-wise, it was right before the Civil War. Dred Scott was a slave, but he was living in Northern Territory for a while. And when his master died, he said, hey, I'm a free man now. But family was, saying you're still property. And his court case went all the way to the Supreme Court. And unfortunately, the Supreme Court said he was property, not a person. And thus it kind of solidified this idea between the North and South about slavery and really one of the ugliest chapters in the history of the Supreme Court, where it declared that slaves were property and not people. And so that's an ugly piece of legislation that happened, and that's why we had a civil war, right? Obviously. Few years later, now we're done with the Civil War, and but we still have people of color, right? Blacks in the South, people of African heritage, who are not slaves anymore because there was amendments added to the Constitution, like the 13th Amendment, which ended slavery. Before the 13th Amendment, there was an executive order type of a situation, the Emancipation Proclamation. But again, it's just a proclamation. The 13th Amendment ended slavery after the Civil War. And then the 14th Amendment was citizenship and where you're born, and doesn't matter your color or creed or religion, right? And then 15th was all about voting rights. So there's a lot of amendments that are slapped onto the Constitution that were a huge deal. But Plessy versus Ferguson, again, is another problematic ruling. So not all the rulings are good. But they established the idea of separate but equal, legalizing racist ideas in the U.S. after slavery was ended. That's as simple as I can say it. So you get Dred Scott and Plessy versus Ferguson, and you see the reason why there is still some discrimination, hate, and problems in our country. Even to this very day, we still have some race riots and issues going on because we haven't come to grips and really treat everyone equal, like the Declaration of Independence clearly says, and like the Constitution is supposed to promote. So it's not a perfect system, but those documents do have good ideas that are supposed to lead us to doing good things. And again, here's another one. In 1954, man, this is almost 100 years after Dred Scott, and we're still making some poor choices as far as the federal government is concerned. Brown versus the Board of Education. This one actually is ended segregation in public schools because people there was separate black schools, right? Separate but equal, and then white schools. But the white schools were getting all the money and the black schools weren't, and it was perpetuating poverty and illiteracy and all kinds of problems. And so Brown versus Board of Education really shook things up. I don't know if you ever saw that movie, like Remember the Titans, where like the integrating schools. My dad grew up in North Carolina during this time period, and he remembers when his high school was integrated. He used to go to an all-white school, and there was another all-black school, and he remembers when he was in high school, they integrated them. They forced integration. They forced blacks and whites to go to the same school to try to equalize things, ended segregation in public schools. So he grew up kind of in the South and told us stories about that and some of the tension that was happening there. Miranda versus Arizona is one of the ones that's really important. I know you guys have all heard this before in like cop shows, but if the police are arresting you and they pull a gun on you and arrest you, they say you have the right to remain silent. You have the right to an attorney. Anything you say or do could be used against you in a court of law. You've heard those on like cop shows. That's because of this case right here established the requirement that police advise people in custody of their rights before questioning them. They try to give you a little history lesson, a little government lesson, a lesson you should be learning in high school, that if you are arrested, you have rights. You're not guilty if you're arrested. You're only guilty if you're proven guilty in a court of law. So you're empowered the more you know. Now, that's not supposed to protect criminals. It's supposed to protect innocent people. Okay? If you're committing the crime, you should do the time. Hands down, period. End of statement. But if you're an innocent person, you should have rights, and the police shouldn't be able to bully you. And so that's one of the issues, and that's a huge issue in our country today. Okay, so Miranda rights, maybe you've heard that term before. We're going to cover that again when we get into, like, say, the Bill of Rights in a couple of weeks, but just kind of wanted to bring it up as a really important one. And again, there's a whole bunch of other court cases. If you're looking at this list and you're like, Mr. Moore, why didn't you talk about this one or that one? That's because this is not an AP class. It's like a regular class just trying to help you become familiar and basically comfortable with some of the key terms. And so I think Roe versus Wade is one of those other like huge deals that kind of pushed for women rights. Women got the right to vote like way back in the 19th Amendment, right after World War I. In between World War I and World War II, okay, we're talking back like 1920s, is when most women got the right to vote in the United States, okay? However, this Roe versus Wade is women's right to choose to have an abortion, uh, being able to take control of their own life and their own feminine health. I don't want to be pregnant. I wanted to not have a baby. I'm not ready for that. And so that was very controversial. And people have very strong feelings both ways. But Roe versus Wade is the court case where the Supreme Court said women do have the right to choose what happens to their own body, including what's inside of their body, even if that's another person. And of course, people have really intense feelings about that. Like some people say, no, it's not really a person, it's just an embryo. Some people say, well, guess what an embryo is? It's a little person. And so huge emotions. And that's one of the things I like about this class is people can have emotions and can express those emotions. Now, again, I just have some cool like Roe versus Wade and Miranda rights and Dred Scott and Brown versus the Board of Education. If you want to come and check out some of the videos, if we were in class and have time, we would do those things. I'm going to kind of whiz through some of these important terms right here at the end. If you ever end up in court and you're being accused of something, then you're the defendant, the one who is going to try to prove that you're not guilty. But remember, you're not guilty. It's actually the burden of proof lies on the prosecution, the prosecutor. They're the ones who have to prove you're guilty. You don't have to prove you're innocent per se. I mean, that's ultimately what you end up trying to do is to prove your innocence. But remember, you start out innocent. At least that's the way it's supposed to be. Okay, so the defendant is the one who gets arrested and who's saying, I didn't do it. And the prosecution or the prosecutor is the one saying you did it and we have proof you did it. Okay, again, most people will require legal counsel. And sometimes they really are called, hey, counselor. Not like a counselor at school who does psychology, but one who counsels you in the law. They're often referred to as an attorney. Or of course, we often just refer to them as lawyers. So attorney and lawyer or legal counsel, those are all words for the same thing. Somebody who's trained in the law who helps you out in court. The plaintiff, right? If you go to court and there's somebody there who's kind of keeping track of all of the logistics that's going on in the court. They're not a judge, okay? And of course, actually inside of the courtroom is the jury, and the jury is selected from regular people. In fact, as I'm recording this here for week 7 of the year 2020, I just got a jury summons in the mail. So regular people, when you turn 18, you'll start to get jury summons, and you have to go in and you can sit in a court. Like, I didn't do anything wrong, but I'm going to sit in the court, and the lawyers are going to talk to us, and the judge is going to talk to us, and they're going to select people to sit on the jury, and they're going to listen to the evidence, and the jury is going to decide if the person is innocent or guilty based on the facts that are presented. So regular people serve on juries. You cannot serve on a jury if you are a police officer or even if you're trained in the law. Somebody like me who just teaches a government class, I know a lot about government, but I can still serve on a jury. I wouldn't be, restricted. Some people don't understand bail. If you get arrested, and this is really significant, some people will post bail, and some people think that you pay to get out of jail, but that's only half truth. If you pay to get out of jail with bail, that means you promise to show up to court. So if you skip bail, then that really looks bad on you. It looks like you're guilty. But say somebody is at a party and they're drinking too much and they're driving home drunk and they crash their car. It's the first time that's ever happened. The judge might grant them bail. They might say, hey, you pay $4,000. Again, it always depends how much money. I'm just throwing out a number, but the judge gets to decide. He says it has to be reasonable, but he has to say, hey, this is your first offense. And then the person might say, hey, I've never done this before. I'm so sorry. Or, anything like that. And the judge might say, well, you can have bail, which means you pay $5,000 and then you can go back home and go back to work as long as a couple weeks later you promise to show up to court on time. Sometimes a judge will not grant bail, like if somebody's been arrested for multiple homicides, murders, the judge might say no bail is granted, but he has to give reason for no bail. So anyways, you can't just pay to get out of jail, but you could pay to get out of jail until your trial, because remember, you're innocent until proven guilty. Courts always follow the example of those set before them. So they follow what they call precedents. Okay. So if one court ruled a certain way, especially if it's a higher court, then judges and lawyers will refer to that and say, hey, look, other courts have ruled in this direction. That seems to be the general way that we're interpreting this law. And so they follow precedents. Remember, I've used this word before. The prosecution has the burden of proof. They're the ones who have to prove you're guilty. Okay, you're already innocent. You just have to make sure everybody knows that. The district attorney is the local person who is the one who's like prosecuting you. He's the one who's enforcing laws at the local level. Remember, ultimately, it's the president who's enforcing the law, but the president's got a huge job to do. So the president has somebody in his cabinet, the attorney general. The attorney general is like the top law, in charge of the Justice Department. And they're the ones who ultimately oversee like FBI and make sure that things like the law is actually being handled, federal marshals and that kind of stuff. And so at the local level, it's usually the district attorney, that's the local attorney, instead of the attorney general in Washington, D.C., who's really doing the prosecuting, okay? An indictment, remember, and I've said this like 6 times, you're innocent until proven guilty. So an indictment is like the official, here's what you're being charged for. If you go to court and you lie, or you go to court and you're acting up, or you're talking crap to the judge, you could be hit with a crime called perjury. There's different kinds of perjury and things that you can get in trouble for. So if you ever find yourself in court, be respectful, follow the rules, dress nicely, use good manners. Those things really do matter. Contempt is another word that's used in case you're not following the rules actually in court. You could be held in contempt of court. Perjury is more the lying part of it, okay, where you swear to tell the truth and nothing but the truth, right? Sometimes in some courts, you'll even put your hand on a Bible and raise your hand, although sometimes that's faded out in certain places. But still, everybody knows that you're required to not lie, but you're required to tell the truth. And if you don't, and they can prove you weren't telling the truth, that's perjury. And contempt is not following the rules of court. Remember that everything comes down to evidence. Evidence is proof, right? And evidence can be used in different ways. The defense might use the same piece of evidence in one direction, and of course, the prosecution might use that same piece of evidence. And you've seen probably movies or court cases on TV or something where people are showing evidence and they're trying to use that evidence to prove something. The evidence itself doesn't do anything. It's the reasoning behind how you use that evidence, okay? There is something called circumstantial evidence, where if one lawyer could say, that's fine, you found a gun at the crime scene, but how could you prove that my client, right, the person I'm defending, how could you prove they're the ones who used it, those kind of things. So circumstantial evidence is stuff that one side is trying to say is like solid evidence, and the other side is saying, no, that really has nothing to do with it. Obviously, it's the jury who gets to prove the verdict, guilty or innocent. And again, if you're ever found guilty in court, but you're really innocent, you need to make sure that you and your lawyer try to appeal that to a higher court. If you're acquitted, means that you're cleared of the crime and you're free to go. You're acquitted. So in the verdict, they might say guilty or not guilty. The jury, of course, after they hear all of the evidence presented by the defendant and the prosecutor, they would go and deliberate. That means they would sit in a private room, they would discuss the facts, and they wouldn't come out of deliberation until they have a verdict. So I'm using these fancy words. If you watch crime drama, you've probably heard these ones used before. And then, of course, depending on the verdict, you could be sentenced, and that means how much jail time you're going to serve, or maybe even death is put on. In some states, not every state does the death penalty. So again, it always depends where you commit the crime, what the crime was. Are you breaking a state law or a federal law? But there still is the death penalty in some states. And so you could be sentenced to death, or sentenced to life in prison, or sentenced to 30 years in prison without the possibility of parole. Or there's all kinds of stipulations. Okay, and that depends on the indictment, right? What you're accused of. If you ever are subpoenaed to go to court, that means that you are legally required to show up to court to present evidence, and you cannot deny that. So if you get a subpoena, if you decide not to follow through, like say you work somewhere and somebody you're working with steals money, and you kind of saw some stuff going on. You weren't guilty, but you kind of know some of the story or some of the talk. The police might come to you, or the court might come to you and subpoena records and say, hey, we need you to testify, and those kind of things. They can't always force it. It kind of depends on the situation. If you're just a witness, they can't force witnesses to testify. But they could legally require you, say if it's your business, to give up business records. That's a subpoena. So there's lots of other fancy words that they use, and this is not, like I said, an AP class. It's just a regular class, so we want to go into all the details. But they use a lot of Latin phrases, and people go to years studying school. If you ever go to serve on a jury, you're going to watch a video. If I was in class, I would probably show you this video. It kind of gives you the basics of hey, are you going to be honest? Are you going to be fair? Remember, the person's innocent until proven guilty, and all those kind of things, okay? So one of the key things about the Supreme Court is it's unelected. We elect people to the House of Representatives and the Senate in the legislative branch. And as you know, we kind of vote for the president, although we really don't. And we're going to talk more about that when it comes to elections. So I'm going to address the Electoral College at a deeper level. But you need to understand that the executive branch is voting. All right, we use the principles of democracy. And the legislative branch, we use principles of democracy, the voice of the people. But remember that the court system is outside of voting. And we kind of wonder why. Why are they outside of that democratic process? And hopefully that means that they're not partial to people's opinions and views. Theoretically, they're supposed to be impartial. Lots of times, if you ever see a painting or a statue of Lady Justice, she's blindfolded. They'll say justice is blind, because you don't care what color people are or what religion they are, or if they're male or female, or rich or poor. We're just looking at facts. That's supposed to be the way it works, okay? But anyways, I have some great videos on understanding a jury and how it works, and even talking about some of the different levels of misdemeanors versus felonies. And there's even different levels of murder if you're accused of murder. And it's second degree. That's way less than first degree murder. First degree murder is like premeditated. You thought it out ahead of time. Second degree murder is more of a crime of passion. You weren't planning to kill anybody, but you did. Manslaughter sounds really bad, but it's even less. It could have been... Maybe it could have been an accident, but you did something that makes it not an accident. If I'm driving home from work and some kid runs out on the road and I hit him with my car, somebody's dead. And my car killed them, but I didn't murder them. I didn't plan it ahead of time. And it wasn't a crime of passion. I wasn't angry. And it's not even manslaughter unless I was drinking. If I had been smoking some marijuana, and then I was driving, and they have proof, like they did a blood test after I hit this kid with my car. Then they could say, "Oh, you could have prevented this if you weren't using drugs or alcohol or something like that." So it all depends on the situation. Again, I'm just giving examples, but I think it's very fascinating stuff. And generally, when we do this lecture in class, it's great because people ask a lot of questions and they learn a lot of great things. It's a little tricky to do this, pre-recorded, but at least you have the basic content. And then I think this is a really important lecture. I hope you listen to all of it. And if you have questions, you bring them to class so you can learn all about courts and the judicial system, because it's a vital part of all of our lives. And honestly, probably the part that's going to affect you the most. Have a great week, and we'll talk to you next week.